I shouldn't answer a question for you, but I will do. If you had the opportunity, who would you put your money on being able to get the case right, stick to the facts, and just score a home run? Dan Goldman or Marjorie Taylor Greene? I'm going with Dan Goldman. I cite example one. Today's this nonsense where they're trying to impeach Secretary Mayorkas. Just watch.
In our great country, Republican members of Congress sworn to support and defend the Constitution are rejecting the framers' clear intent and over 2 centuries of precedent in favor of a sham impeachment. Republicans have failed to make a constitutionally viable case to impeach Secretary Alejandro Mayorkas, a dedicated public servant. The sham impeachment of Secretary Mayorkas is a baseless political stunt by extreme MAGA Republicans. Chairman Greene, Representative Margaret Taylor Greene, and others have pushed for and even fundraised based on this pre-planned, predetermined scapegoating of the Secretary. In a process akin to throwing spaghetti at the wall and seeing what sticks, Republicans have cooked up vague, unprecedented grounds to impeach Secretary Mayorkas, refusal to follow the law, and a breach of public trust. Neither of the impeachment charges the committee will consider today are a high crime and misdemeanor under Article 2 of the Constitution. No serious person believes they are. Refusal to follow the law or maladministration was deliberately rejected by the framers as grounds for impeachment. Indeed, no official in American history has ever been convicted after impeachment for refusal to follow the law. These disputes are settled in the court system, not through impeachment. Apparently, Republicans are upset they lost in court and are trying to relitigate their cases through impeachment. The Constitution does not allow that. Breach of public trust requires conduct intended to serve an official's own benefit or the benefit of a foreign power. No serious person can allege that Secretary Mayorkas' action meet the standard for breach of public trust under the Constitution. Nevertheless, throughout this truncated impeachment process, Republicans have ignored the facts and misrepresented the law to justify their scheme. But the law is clear, and so is Secretary's record. He's leveraged the full range of authorities at his disposal while stretching the resources provided by Congress to secure the border. He has removed record levels of migrants detained by more people than Congress has provided funding for, and prevented record levels of fentanyl from entering our communities. Constitutional law experts agree the Secretary has not committed any impeachable offense. Rather, he has faithfully implemented the administration's border policies Republicans apparently disagree with. But policy differences are not impeachable. House Republicans' impeachment of Secretary Mayorkas accomplishes nothing, which would be consistent with their abysmal record this Congress. At a hearing before the committee this month, constitutional scholar Professor Deborah Pearlstein said, quote, "No branch of government has more power under our Constitution to address matters of border security than Congress," unquote. At every opportunity, Republicans have turned their backs on legislation to provide resources to the Department of Homeland Security. In doing so, they are turning their backs on border agents and officers. If House Republicans were serious about improving conditions along the border, they would provide the department the funding necessary to do so. They have not. If House Republicans were serious about improving conditions at the border, they would negotiate border security legislation with the White House and the Senate. They have not. Instead, they sat on their hands as a bipartisan group of senators worked with the Biden administration to hammer out a deal. The extreme MAGA Republicans who are running the House of Representatives are deeply unserious people. They don't want progress. They don't want solutions. They want a political issue. And most of all, they want to please their disgraced former president. House Bipartisan border bill and urge Republican governors to defy a United States Supreme Court order ensuring the Border Patrol can do its job, including members of this committee also. The impeachment of Secretary Mayorkas is designed to distract the public from the fact that Republicans have ceded their power to Donald Trump. When Republicans took control of the House of Representatives, they had an opportunity to work with the White House and the Senate to move the country forward, and futile political exercises like impeachment to satisfy the extreme MAGA base. The MAGA-led impeachment of Secretary Mayorkas is a baseless sham, and the few rational Republicans left in the House know that, even if they refuse to admit it. The American people deserve better. Mr. Chairman, I ask unanimous consent to include in the record the Democratic report on this so-called impeachment.
Without objection, so ordered.
I also ask unanimous consent to include in the record a letter dated today from Secretary Mayorkas to you, Chairman Green, detailing the actions the department has taken to secure the border and be responsive to Congress.
Without objection, so ordered.
Mr. Chairman, history will judge what Republicans are doing here today, and it won't be favorably. This impeachment scheme is a dangerous attempt by House Republicans to distort the Constitution and the Secretary's record to cover up their inability and unwillingness to work with Democrats for the betterment of our constituents. Our service to this country demands that we be passionate in our beliefs and practical in our actions. The strength of our nation is rooted in our commitment to democratic principles and our willingness to set partisan differences aside to protect them. There are few better examples than former Republican Secretary Michael Chertoff, who cautioned this week that impeaching Secretary Mayorkas over policy differences would damage the Constitution. He wisely observed, quote, "Our nation is at its best when our leaders work together to confront the seemingly intractable. The situation at our border and our national security demand such bipartisan collaboration," unquote. He went on to say, quote, "Despite our different parties, I know Mr. Mayorkas to be fair and honest, dedicated to the safety and security of the United States. He has represented DHS to the country and to both parties in Congress with integrity," unquote. That is the kind of bipartisanship we need to solve our border challenges. In fact, it appears our colleagues in the Senate are on the verge of reaching a bipartisan border deal. It's not too late to work with them to get the bill signed into law. I urge my colleagues to honor their oaths to the Constitution and drop this sham impeachment, and to give my colleagues a chance to rethink this political stunt. Mr. Chairman, I move that the committee do now adjourn.
The gentleman's motion is privileged and non-debatable. The question is now occurs on the gentleman's motion. All in favor say aye. Aye. Those opposed say no.
On that vote, Mr. Chairman, there were 18 ayes and 14 noes.
The ayes have it, and the reading of the resolution is dispensed with. And it is considered read and open to amendment at any point. I now recognize myself.
Mr. Chairman.
For what purposes the gentleman seek recognition?
Mr. Chairman, I ask unanimous consent to include in the record the text of Rule 1, Article 16, that members must reduce to writing any motion.
Without objection, so ordered. I now recognize myself for the purpose of offering an amendment. The gentleman, for what purpose?
Mr. Chairman, pursuant to Clause 3 of Rule 16, I raised a question of consideration.
Committee will suspend. The gentleman, what is your question relating to?
In terms of having the
I raised the question of consideration.
right, I raised the question of consideration.
Will the committee consider the bill?
Will the committee consider the bill?
To which measure?
Res 863.
The gentleman from Mississippi raises the question of consideration. The question is, will the committee now consider Res H63? All those in favor signify by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the motion is not agreed to.
Mr. Chairman, I ask for a recorded vote.
Gentleman asks for a recorded vote. The clerk will call the roll.
Mr. McCall. Aye. Mr. McCall votes aye. Mr. Higgins. Mr. Higgins votes aye. Mr. Guest. Aye. Mr. Guest votes aye. Mr. Bishop.
Aye.
Mr. Bishop votes aye. Mr. Jimenez.
Aye.
Mr. Jimenez votes aye. Mr. Pfluger. Mr. Pfluger votes aye. Mr. Garbarino.
Aye.
Mr. Garbarino votes aye. Ms. Green.
Aye.
Ms. Green votes aye. Mr. Gonzalez.
Aye.
Mr. Gonzalez votes aye. Mr. Lalota. Mr. Desposito votes aye. Ms. Lee. Ms. Lee votes aye. Mr. Luttrell. Mr. Luttrell votes aye. Mr. Strong.
Aye.
Mr. Strong votes aye. Mr. Burkeen.
Aye.
Mr. Burkeen votes aye. Mr. Crane. Mr. Crane votes aye. Ranking Member Thompson.
Nay.
Ranking Member Thompson votes no. Ms. Jackson Lee.
No.
Ms. Jackson Lee votes no. Mr. Payne. No. Mr. Payne votes no. Mr. Swalwell. Mr. Correa. No. Mr. Correa votes no. Mr. Ivey votes no. Mr. Goldman.
No.
Mr. Goldman votes no. Mr. Garcia. Mr. Garcia votes no. Mrs. Ramirez.
No.
Mrs. Ramirez votes no. Mr. Menendez. Mr. Menendez votes no. Ms. Clark. Ms. Clark votes no. Ms. Titus. Ms. Titus votes no.
How am I recorded? Or how is Mr. Lalota recorded?
Mr. Lalota is not recorded.
I vote yes.
Chairman, there were 18 ayes and 14 noes.
The motion is agreed to. I now recognize myself for the purpose of offering an amendment in the nature of a substitute. The clerk will report the amendment in the nature of the substitute.
Point of order.
What purpose are you recognized?
Mr. Chairman, I raise a point of order against amendment in the nature of a substitute. Clause 7 of Rule 16 states that no motion or proposition on a subject different from that under consideration shall be admitted under color of amendment. But immigration is not our committee. We don't get to solve the immigration problems, end quote. As this amendment falsely alleges that Secretary Mayorkas has refused to comply with federal immigration laws, this amendment is not germane to the committee's jurisdiction according to the chair's June 23rd statement, as well as Clause 1J of Rule 10, and I insist on my point of order.
The point of order is overruled, and the reason is that the House voted to send this call the roll. The gentleman from Mississippi moves to table.
Mr. Chairman, I demand a motion.
Gentleman's
Pursuant to
recognized.
Clause 1 of Rule 16, I demand a motion to reduce to writing and report it by the clerk.
The committee will suspend. The committee will suspend.
That's okay.
Submitted for the record. The movement to the table has been submitted in writing. Are we voting on it? Okay. The clerk will call the roll on the motion to table. The clerk.
Mr. McCall. Aye. Mr. McCall votes aye. Mr. Higgins. Aye. Mr. Higgins votes aye. Mr. Guest. Aye. Mr. Guest votes aye. Mr. Bishop.
Aye.
Mr. Bishop votes aye. Mr. Jimenez.
Aye.
Mr. Jimenez votes aye. Mr. Pfluger.
Aye.
Mr. Pfluger votes aye. Mr. Garbarino. Mr. Garbarino votes aye. Ms. Green.
Aye.
Ms. Green votes aye. Mr. Gonzalez.
Aye.
Mr. Gonzalez votes aye. Mr. Lalota.
Aye.
Mr. Lalota votes aye. Mr. Ezell. Mr. Ezell votes aye. Mr. D'Esposito. Mr. D'Esposito votes aye. Ms. Lee. Ms. Lee votes aye. Mr. Luttrell. Mr. Luttrell votes aye. Mr. Strong. Mr. Strong votes aye. Mr. Burkeen. Mr. Burkeen votes aye. Mr. Crane. Mr. Crane votes aye. Ranking Member Thompson.
Nay.
Ranking Member Thompson votes no. Ms. Jackson Lee.
No.
Ms. Jackson Lee votes no. Mr. Payne. No. Mr. Payne votes no. Mr. Swalwell. Mr. Correa. Mr. Correa votes no. Mr. Carter. No. Mr. Carter votes no. Mr. Tanadar.
No.
Mr. Tanadar votes no. Mr. Magaziner.
No.
Mr. Magaziner votes no. Mr. Ivy.
No.
Mr. Ivy votes no. Mr. Goldman.
Nay.
Mr. Goldman votes no. Mr. Garcia. Mr. Garcia votes no. Mrs. Ramirez. Mrs. Ramirez votes no. Mr. Menendez. Mr. Menendez votes no. Ms. Clark. Ms. Clark votes no. Ms. Titus. Ms. Titus votes no.
How's the chair recorded?
The chair is not recorded.
Chair votes aye. Clerk
Chairman
will tally-
Green votes aye.
Clerk will tally the report, the tally.
On that vote, Mr. Chairman, there were 18 ayes and 14 noes.
The tabling motion stands, and the motion is moved to the table. Without objection, the clerk will report the amendment in nature of a substitute.
An amendment in the nature of a substitute to H-Res 863 offered by Mr. Green of Tennessee.
Without objection, the reading is dispensed with. I now recognize myself to explain the amendment in the nature of a substitute. This amendment is in the nature of a substitute, expands on the underlying resolution by including 2 articles of impeachment. Article 1 relates to Secretary Mayorkas' willful and systemic refusal to comply with the law, and Article 2 relates to his breach of public trust. The amendment in the nature of a substitute also includes updated figures regarding illegal border crossings and other statistics. With that, I yield. Is there any further discussion on the amendment in the nature of a substitute?
Mr. Chairman, may I be recognized?
Yes, you may. You're recognized for 5 minutes.
We're here based on two completely fabricated, unsupported, and never used before articles of impeachment. This is completely debasing and demeaning the impeachment clause of the United States Constitution, and it is a gross, gross injustice to the credibility of this institution. In your opening statement, Mr. Chairman, you quoted James Madison as saying that the impeachment clause is designed to remove bad men in office. But notably, the impeachment clause is not designed to remove bad policy from the office. And the definition of bad men, as Professor Pearlstein said, is an individual who abuses his power for personal gain. It has never, ever, there's never been an impeachment in the history of the United States where someone has been impeached for something other than the abuse of power for purposes outside of his official duties. That is for elections, and that is for legislation. This, on the other hand, is an impeachment process that you are moving forward because you claim that Secretary Mayorkas, who's obviously working under the direction of President Biden, is failing to secure the border. The irony of the fact that Secretary Mayorkas has spent the last 2 months plus with a bipartisan group of senators negotiating legislation that would address the problems at the border should not be lost on anyone. You are sitting here right now trying to impeach a Secretary of Homeland Security for neglecting his duties literally while he is trying to perform his duties and negotiate legislation. Now, the real reason we are here, as we all know, is because Donald Trump wants to run on immigration as his #1 issue in the November 2024 election. And you don't have to take my word for it, because he said it himself. And last week, numerous Republicans echoed his call. Why would we actually solve the problems at the border when it is such a good political message to use for the election? And Leader McConnell even reiterated in a closed-door meeting of the Republican members of the Senate that we're in a quandary, he said, because our candidate wants to run on immigration, and we don't want to get in the way of our candidate. Now, I know this weekend I saw Chairman McCall on TV and others, and you're changing your tune now because you said the quiet part out loud that this is all about politics, and so now it's, oh no, the president can do it without legislation. Never mind that you've been calling for H.R. 2 this entire Congress. No, now it's he can do it himself. Well, he's tried to do it himself. He's tried. He's passed numerous policies that would have streamlined the asylum process through ports of entry where migrants are vetted, that would have presumptively made ineligible anyone trying to cross the border in between ports of entry, and would have done a number of different things to address the problems. Republicans went to court to sue him, to stop him from implementing the policies to address the border. So your own party is sabotaging and undermining this administration's efforts to address the border while you are trying to impeach him by saying that they're not addressing the border. The hypocrisy is the least of it. Your attack on the rule of law And our democracy is the worst of it. And you better be careful about the bed that you make. I yield back.
The gentleman yields, and I appreciate the gentleman keeping his remarks within the 5 minutes. Because the day is going to be long, I will not, we're not going to do the typical over 5 minutes if you're continuing a thought. So keep your comments to 5 minutes, please. I now recognize myself for 5 minutes. I'd like to specifically talk about the Supreme Court's ruling, the United States versus Texas. President Biden's appointed Solicitor General, Elizabeth Prelogar, made a stunning claim asserting that no state, individual, or business has standing to challenge an administration's decision to, as a blanket matter, not enforce any particular law. When pressed by Justice Brett Kavanaugh if states and individuals were precluded from challenging this lack of enforcement, the president's own secretary or Solicitor General responded, "That is correct, but the framers intended political checks in the circumstances. Congress has tools at its disposal." Justice Kavanaugh responded, "I think your position is instead of judicial review, Congress has to resort to impeachment or dramatic steps in the face of such defiance of the laws passed by Congress." Prelogar's rejoinder was that in the face of dramatic abdication of statutory responsibility by the executive branch, such steps would be warranted. In other words, if the Biden administration's own legal position, it is the Biden administration's own legal position before the Supreme Court that impeachment is proper remedy for dramatic abdication of statutory responsibility. Meaning, if a secretary is not adhering to the laws passed by Congress, the only recourse, because the states now don't have standing, is for the Congress to impeach. That is the rulings of the Supreme Court and the argument brought forward by President Biden's own Solicitor General.
Will the gentleman yield on that point?
I'll finish and then you can be recognized, Mr. Ivey. I think it's pretty clear that in that Supreme Court ruling, the state wasn't given standing. Now, the Supreme Court did not rule on whether or not the gentleman, the secretary, was adhering to the laws or not. But the discussion was about what do you do when they're not? And the conclusion of the court in the minority opinion, or majority opinion, was both by Alito and Kavanaugh, impeachment and actions of the Congress are the only place for recourse of a situation like that. That's why we're where we are today. We have a secretary who has, the law is very clear, shall detain. It doesn't say create policies to allow for people to immediately be released in the country. It says shall detain. And that was not done. In fact, systems were created to do just the opposite of that. That is a violation of the Immigration and Nationality Act. It's actually willful and systemic. And when courts ruled you can't do that, he just repackaged it and continued to do just that. And the Supreme Court agrees that the only recourse is for Congress to take action when a secretary, and I will use the Solicitor General's own words, dramatic abdication of statutory responsibility. I yield. I yield my 5 minutes, and whoever else wants to be recognized.
Recognition.
Mr. Ivey, you are recognized.
Thank you, Mr. Chairman. With respect to the comments you just made, I refer the chairman and the committee to the actual opinion that was written by Justice Kavanaugh, which is the one that has the force of law, not necessarily the discussion with the Solicitor General Prelogar. But on this particular point, the allegation that's being made in the articles of impeachment is that there's a willful defiance of enforcing the law. Justice Kavanaugh, with respect to that point, wrote this: as the district court found, the executive branch does not possess the resources necessary to arrest or remove all of the non-citizens covered by these two statutes. That reality is not an anomaly. It is a constant. For the last 27 years, Since those statutes were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests. In other words, what he's saying, and this is in the context of the court's reference to cases like Waite, and those are prosecutorial discretion cases. For decades, the Supreme Court has deferred to the executive branch the right to make decisions about what to enforce, what not to enforce, and how to enforce it. And that's exactly what he's saying here. And it's especially powerful here because this deals with enforcement of the immigration laws, which is given special deference to the executive branch. So the language you just read and the article, the first section of the impeachment, are totally negated, not only by this language, but by the long history of the Supreme Court deferring to the executive branch and deciding what to enforce and how to enforce it. And that's exactly what we've got here. I think the argument that Secretary Mayorkas has not enforced these laws, he might not have liked the way he's done it, but I think it's clear in the letter he sent to the committee. And by the way, I thought it was totally appropriate for him to send the letter after the articles of impeachment had been released, since his comments should be related to the articles. But anyway, since May 12, 2023, DHS has removed or returned more than 500,000 individuals. Daily removals and returns are nearly double what they were compared to the pre-pandemic average of 2014 to 2019. I refer to page 2 of his letter, which is dated January 30, 2024. You all can read it and get the rest. But the point is this. The language that you're talking about, as the professor testified, is a total failure to do the job. And the points that she pointed, the issues that she pointed to were things like addiction or, physical inability to perform. We don't have that here. And the language that's in the letter that he sent and the data that's backed up by it show that he's actually been working on the job and doing the work, as done the recognition by the Senate, Democrats and Republicans, who've called him to the Hill to negotiate, as they're negotiating a bipartisan solution to the problem. Unfortunately, we haven't done that, but they recognize that he's doing the job. And then the last point I want to make, your reference to...
Gentleman, yield for a question.
I can't because I'm running out of time. The last point I want to raise, though, is that your reference to impeachment being the only tool available, and this is page 14 of the opinion. This is still Justice Kavanaugh. For example, this is where he's talking about options since there's no standing. What can Congress do instead? For example, Congress possesses an array of tools to analyze and influence those policies: oversight, appropriations, the legislative process, and Senate confirmation, and through elections. He does not mention impeachment. In fact, I'm not sure I saw impeachment mentioned anywhere in the opinion that he wrote. And by the way, there's a concurrence from Justice Gorsuch. All 3 of the Trump nominees to the Supreme Court agreed with this language. None of them supported the position that you just outlined. And it was an 8-to-1 decision. The articles of impeachment rely on Justice Alito's language. He's the sole dissenter in this case. So just based on the constitutional law as explained by the Supreme Court in the case that you cited in the article cite, it comes out exactly the opposite and undermines the claims that somebody could be impeached in the executive branch for following executive authority that the Supreme Court recognizes as theirs, especially in immigration cases, and that's been true for decade after decade. I yield back.
Gentleman yields. I now recognize Ms. Green for 5 minutes.
Thank you, Mr. Chairman. Congress has the responsibility to hold the executive branch accountable when they fail to uphold their oath of office, abuse their authority, and/or are dishonest with the American people. This is essential in a constitutional republic built on and separation of powers. In its 2023 ruling in United States versus Texas, the Supreme Court left the House of Representatives with little choice but to pursue impeachment articles against Secretary Mayorkas. The 5-4 majority did not address the Secretary's policies and mandates on the merits, but simply ruled the states did not have the standing to challenge them. Instead, the justices wrote that Congress has political tools available to push back on these policies. The only one that makes sense in the current political environment is impeachment. Remember, Democrats have completely rejected H.R. 2, our strongest security bill for our border. Secretary Mayorkas' actions and decisions clearly meet the standard necessary for initiating impeachment proceedings. This historical evidence is overwhelming that the Founding Fathers intended impeachment to be used to deal with the commission of indictable crimes and the abuse of power, corruption, and injury to the nation caused by public officials, among others. At the Constitutional Convention, the framers purposely devised the impeachment power to include any offenses against the nation's security committed by high officials. Stephen Bradbury, former principal deputy and acting assistant attorney general for the Office of Legal Counsel at the Department of Justice, there is a settled understanding beyond dispute that impeachable offenses include both prosecutable crimes and all manner of gross misconduct in office that does serious harm to the U.S. political system or the U.S. constitutional order. The actions, policies, and statements of Secretary Mayorkas easily meet that standard, and the American people completely agree, especially the witnesses that we've had before this committee, these parents who have had children murdered by fentanyl, murdered by illegal aliens, such as MS-13 crime gang members, and so much more. And I would tell you right now, the family of my two constituents that were killed in a horrific car accident by a 17-year-old cartel member smuggling illegal aliens into Texas would definitely agree with that. Secretary Mayorkas must be impeached for his failure to uphold his oath of office and for willfully breaking federal immigration laws. Mr. Chairman, I yield back my time.
Gentlelady yields. I now recognize Mr. Garcia for 5 minutes of comment on the amendment in the nature of the substitute.
Well, thank you, Mr. Chairman, and we should certainly, I think, be embarrassed to be here today. This is a complete impeachment.